to our two moderators who will moderate this session. You may have met our first moderator, Donny Surtani. He's the co-chair of CanArb, but Donny wears many hats, and in addition to co-chairing CanArbWeek, he is also the fellow of the Chartered Institute of Arbitrators. He's a mediator accredited with the Center for Effective Dispute Resolution in London. He's a guest lecturer at the Queen Mary University of London, Oxford Hall Law School, and the International Academy of Financial Crime Litigators. Donny is licensed in both Ontario and England and Wales, having spent 15 years in London as a partner at Herbert Smith Freehills. Before turning to the dark side and becoming a lawyer, Donny was also a chartered management accountant, and he's also one of the people who created the YCAP Secretariat Costs report, so he's uniquely placed to moderate the first portion of the event during which the findings of the report will be presented. The second portion of the event will be moderated by Ekin Cinar, who is an associate at Tempton's Toronto office, where she practices commercial litigation, commercial arbitration, as well as investor-state arbitration. She has particular experience in matters relating to construction, energy, mining, and shipping sectors. Ekin is dual qualified, as she is a lawyer both in Ontario and Istanbul. Before moving to Canada, Ekin practiced for nearly a decade in Turkey, where she represented clients in a wide variety of cases under different institutional rules as well as in ad hoc arbitrations. With that, I leave you in the capable hands of the moderators and with the speakers who will do their best to present this topic in the time allotted. Thank you.
Thanks so much, Dina. Hi, everyone. So we're going to try and keep this first segment looking at the report, the survey report and its results pretty snappy, and then we can pass on to Ekin and her panel to unpack some of these issues a bit further. A few words on what led to this survey. There was a sort of discussion among some of the folks in YCAP about a need to have a better understanding about costs in arbitration, which are otherwise confidential, and your knowledge about what costs are incurred and what costs are recovered and how that works would otherwise be restricted to the anecdotal, what you know from the folks sitting in the same corridor as you. So we were keen to try and get a better understanding of that, and we were really keen to have the support of the folks at the Secretariat who did all of the heavy lifting for us. And so we recognize that arbitrations require investment by the parties and sometimes by external funders and potentially insurers, adverse cost insurers. And so in order to analyze that investment decision properly, parties need to understand the possible outcomes on the substantive claims, for sure, but it can also be important to understand the position in terms of costs. How much of my costs might I get back? How much of my opponent's costs might I have to pay? And those metrics are an important part of the investment decision process. And so it's also then important in thinking about that to understand why cost awards are being made. What factors do parties rely on when seeking to claim their costs? And what factors do tribunals find persuasive when making their decisions? So that gave rise to the survey project. A number of you in this room might remember getting emails from YCAP over a period of time trying to collect survey data. We're pleased to say we got survey responses on more than 50, about 54 arbitration cases, which Chris and Inkoo analyzed comprehensively on an anonymized basis. So the lawyers within YCAP saw none of the data except on an anonymized basis. We then came together to write the report that went on to YCAP's website a few months ago. We had a few minutes on this at the CanArbWeek session last October, but we obviously didn't have a huge amount of time to unpack it. So I'm really glad that we have now a little bit more time to explore the data with the team that did such an excellent job with it. And so with that, I'll hand over to Inkoo to give you a little bit of an overview of the survey data.
Thank you, Donny. After Donny's inspiring introduction, you may eager to learn about how the data look like, which is gathered from the survey. As a financial analyst and the damages expert, when I received the raw data, it was very unconventional types of information, full of the qualitative narrations. So it was very, at the beginning it was tough, but I made a significant effort with YCAP members to convert it to quantitative format so that we can clearly present it to graph and chart and tables. So let's look at the numbers. So we analyzed 54 arbitration cases. Of these, 42 were domestic and 12 were international cases. 23 cases were managed under the institution's administration, while 31 were handled ad hoc. Next. The arbitrations about the dispute amount, arbitrations concerning disputes of $100 million represented the most substantial portion, nearly 25% of cases surveyed. This trend was consistent within various arbitration subgroups, whether they are in ad hoc or institutional groups, or a subgroup of domestic or international arbitrations. The cases for non-monetary relief were prevalent in domestic settings with 10 instances. In contrast, only one such case was provided in the answer under the international arbitration setting. Regarding the tribunal composition, 14 cases used 3-member tribunal, typically involving larger dispute amounts, as you see on the chart. With a dispute amount often exceeding $100 million, while a single arbitrator resolved 72% of the cases, amounting to 39 cases in total. Geographically, arbitration seats were distributed as follows. Ontario hosted 16 cases, Alberta 15, and British Columbia 13, Quebec 6, and Saskatchewan had 1 case within the survey answer.
Thanks, Inkoo. So with that sort of profile of the source data, do you think, Chris, you could talk to us a little bit about the level of costs incurred and recovered that we saw from the data?
Sure. So one of the main questions that the survey sought to answer was how successful are claimants and respondents in recovering their costs. And so I'm going to just run through what we saw from the data. So starting with claimants, so we had 13 claimants that had successfully won their case and claimed costs. And of those, 7 received 100% of their costs. None of them, well, all of them received some amount of costs. So there was none that got shut out. And the average recovery was 80%. So that's for successful claims. There were also claims that were described as being a mixed success. And for those, we had 14 responses. 2 of those received 100% of their claimed costs, which sort of to be expected. Less success, you're going to get a lower amount. 5 of them didn't receive any amount. And the average recovery there was 37%. So sort of expected, if you win your case, you would expect to get a high amount of recovery, and that's what we saw in the data. Turning to respondent. So there we had 10 cases where respondent was successful, where the claim failed. Respondent successfully defended their claim. Of those, none of them received 100% of their claimed costs, but as you can see, the yellow dots on the chart there. 4 or 5 of them, 4 received over 80% of their costs, and 1 was about 70. So 2 of them didn't receive any costs. So, and the average recovery there was about 53%. So a lot lower than the claimants when they were successful. So that's sort of an interesting conclusion here. So for the mixed success for respondents, there were 12 cases there. Again, none of them received 100% of their costs. And actually 10 of them were completely without any costs. So only 2 received some amount of costs. And on the chart you can see the blue, they're around 60%. So the average recovery for the mixed success category was around 11%. So again, well below that of the claimants. So that sort of summarizes that aspect of the survey.
Thanks for that, Chris. And so it's interesting to see some variation between the higher recovery levels for successful claimants versus the somewhat lower recovery levels of successful respondents. And if you're wondering why that might be, well, they were all decisions taken by arbitrators, some of whom were in the room. So I guess the question's on you guys. But what did we learn, Chris, about how much this varied between domestic and international cases, or as between ad hoc and institutional cases?
Sure. So when we drilled into the data a little bit more and compared the results between domestic and international and between ad hoc and institutional arbitrations, we do see some differences. So for cases where there were clear outcomes, so there was a clear winner, when we compared domestic and international, domestic had a higher percentage recovery at 88% or 89% as compared to international, about 62%. And for mixed success, domestic again had a higher percent of recovery at around 72% compared to international 36%, so double for the mixed success for domestic versus international. And then when we compared ad hoc and institutional, for clear outcomes, institutional arbitrations had a higher recovery at 89% compared to 77% for ad hoc. And that flipped for mixed cases where ad hoc had a higher recovery at 69% versus institutional at 58%. So domestic seemed to be a higher recovery under both, whereas it sort of flipped between ad hoc and institutional, between mixed success and clear outcome. But we need to be a little bit careful with this because the data is it was sort of a small sample size. As you can see, there were only 3 international cases for the mixed success and 4 for clear outcomes. So whereas this describes the data that was in the survey, you can't necessarily extrapolate to all arbitrations. And in fact, the only aspect that kind of held true through all 4 of these categories was that the average cost, where the average cost claim was lower, that had the higher recovery. So I think it's probably indicating that, that it's probably more of depends more on the actual attributes of the claims themselves rather than these attributes of the arbitration. So that's a summary of that.
Thanks for that, Chris. And I should say we don't mean to do an eyesight test with this, but it hopefully gives you a taster so you go on the YCAP website and get the report. We should
just ask
go ahead.
whether there was a correlation, or you test for a correlation in terms of percentage of recovery, where there was a sole arbitrator as opposed to a 3-person tribunal. Did you do that correlation? That would be interesting.
So that's a great question. I have to say, from memory at least, I feel like if there had been one, we would have put it into the report. I suspect if it's not in there, it's because there wasn't a sort of a clear signal coming from the data. We're obviously skipping through this at a bit of a speed, but one of the things that we did have in some of those charts was looking at costs as a proportion of claim value, and then how much gets recovered. So you can get a bit of a sense of that. But we've seen some information now in Inkoo about the how much types of questions. But what did we learn about the why questions? What arguments were deployed about why a party should recover some of its costs, and to what extent did these arguments resonate with tribunals?
Thank you, Donny. So to answer that, let's look at figure 21. Let's take a closer look at figure 21. The survey question allowed multiple responses about how and why questions. So we gathered 88 responses detailing why the party should recover some of its costs and how these arguments are justified before the tribunals. So the first case, the most largest number, the most prevalent argument revolved around the known that the losing party should bear the most of the winning party's cost, with 31 cases. And the next was the outcome of the claim with 21 cases. Most of them were well referenced in the cost order. And I'd like to add my personal experience about that I learned that this is specifically a Canadian case. In October 2023, I had the opportunity to bring this report to Seoul ADR Festival in South Korea. And there, with Bruno, a YCAP member based in Japan, I hosted an event to discuss the landscape of arbitration costs in Asia Pacific region based on this report findings. And with this experience highlighted how the answers about the norm that losing party bear the most of the winning party's cost might differ across jurisdictions. So I'm not the legal expert, but that's what I learned. Returning to our Canadian cases, the next largest observation was settlement-related conduct. It also played a significant role. References to the past offers were noted 11 times, and 10 of them influenced tribunal's decisions on awarding costs. Refusal to mediate rarely used as a cost-related argument. In 2 cases, parties claimed cost based on proven dishonesty. However, tribunal did not accept this argument. Interestingly, in one case where dishonesty was alleged but not proved, was accepted by tribunals, as shown in figure 21. To understand this case better, there is another aspect to consider. The respondent substantially beat the settlement offer in this specific case, which led to a significant cost recovery, 96% on a full indemnity basis. So therefore, dishonesty alleged but not proved is not the only factor considered in the cost award. There are 8 instances whether the conduct of parties, 7 cases and 1 cases, conduct of parties or conduct of counsel was used to argue for costs. Yet only 3 of these influenced tribunal's cost award decisions. And earlier I mentioned that my effort to convert the survey information into quantitative so that you can convert it to the chart and tables. So what you see in figure 21 is the result of that effort. But to address this current topic, why costs are claimed, awarded, and how they compare between successful claimant and respondent, it requires more explanations, which cannot be presented simply in the chart. So I bring those details back to this presentation. And we have selected 2 cases and presented in the report to address this aspect. Thankfully, the survey participants provided insightful details for this analysis. So first, we have a case that failed on the merit. So the tribunal considered settlement offered and decided to award the respondent 50% of its legal fees plus 100% of its disbursement to the successful respondent. So this case is aligned with what we have observed in the previous section of our report, that the successful respondent's cost recovery was generally lower than that of successful claimant. So in this specific case, tribunals cited the norm of the arbitration and past offers made in their decision. and explained that it was reasonable for the claimant to bring their claim. Thus, the tribunal refrained from awarding full indemnity cost to the successful respondent. So I think this could be one of the explanations on why the cost recovery of successful respondents can be generally low. I hope this analysis is helpful for you to understand the complexity of the cost recovery in arbitration. Thank you.
Thanks, Inkoo. Thanks, Chris. I'm sorry we need to sort of keep it moving, but we will hand over to Ekin now. We'd love to chat with you more about what you find in the survey report. Please do come and find us. Thank you so much.
Good afternoon, everyone. Thank you, Donny, Chris, and Inkoo for the first part of the YCAP panel. We have now a panel discussion about do's and don'ts of cost awards. In our panel, we have Stephanie Cohen. She is a Canadian arbitrator of international and domestic commercial disputes. She's based in New York. Stephanie has over 20 years of experience specialized in the arbitration of complex commercial disputes. She's admitted to practice law in New York and in Ontario. Then we have Hugh Meighen. He's a partner in BLG. He has more than 15 years of experience in dedicated arbitration counsel work. He has extensive experience in representing clients in high-value and complex disputes under various institutional rules and ad hoc arbitrations. And then we have Geoff Moysa. He is an investment manager and legal counsel in Omnibridge-based Toronto office. Geoff provides claimants, corporations, and counsel with strategic advice and analysis on their claims and acts as a strategic partner to law firms acting on funded cases. Prior to joining Omnibridge, Geoff was a partner at Macmillan, where he practiced commercial litigation over 10 years. And finally, we have Pietro. Paul is a counsel with North America case management team of the International Court of Arbitration at the International Chamber of Commerce. Paul is an international lawyer with experience in arbitration and as well as in complex commercial transactions and cross-border litigation. So, Paul, I will start with you, and I think Stephanie will also chime into this question. We see a couple of minutes ago that there are some differences between international and domestic cases. And I wonder if you see any cultural or regional differences that influence the approach to cost awards in international arbitration.
Thank you, Ekin. Well, I think there are, and to start with, the ICC Commission report on decisions on costs in international arbitration highlighted back in 2015 that arbitrators' approaches to the allocation of costs are often influenced and informed by the practice in the local courts of their jurisdiction or the laws applicable in the country of origin of the parties or the arbitrators or the laws of the place of arbitration. I also do think that parties to an international arbitration arguably have some sort of expectations in respect of costs that may be influenced by their legal or cultural background, which is why I think it's a good practice to address cultural expectations early in the proceedings to avoid any potential mismatch of expectations. And just to give you some, to name a few basic examples of regional differences that may influence the approach up to cost awards in international arbitration, and none of them are very novel. So for most US lawyers, depositions are an essential tool for presenting their case, yet they are not necessarily part of an arbitration proceeding, and there are other means to present their case, witness statements. So these depositions normally add an additional costly layer to the proceedings. Also in some jurisdiction, the recovery of costs under fee arrangements is generally acceptable, whereas in other jurisdictions it is not. Same applies to recovering third-party funding costs. In some jurisdiction, it may be permissible, whereas in others, it is not for different reasons. Another example, in some Canadian cases, parties often seek an award on costs, including all applicable taxes, including the harmonized sales taxes, whereas in cases involving parties from other jurisdictions, sometimes you don't have a relief on the applicable taxes. Another example, under Brazilian law, the party defeated in any litigious proceeding, either arbitral or judicial, may be required to pay the winning party's counsel some sort of success fee. And we have had Brazilian parties in some of our cases seeking an award of this winning fee. Whether that's a relief available in the context of an arbitration, that's still hotly debated. But I'm sure that Steph, you have other examples.
But I think that was actually really good at giving a picture of some of the ways in which you can see people end up being surprised about different approaches, and that's I think we understand generally that the norm in international arbitration is loser pays, and I say we as a room full of people who practice in this area, but when you have counsel who are not as familiar with it, they are often surprised. You see that in cost submissions, and I think the examples that you gave are instances where then you see some of that clash. Maybe just one other comment on this topic. Given the YCAP Secretariat report, it might be of interest for folks in this room to know that the New York City Bar Association's International Commercial Disputes Committee has a report on costs that I had expected would be published by now, but should be published any day on the New York City Bar Association website that looked at a very similar kind of question. How do international arbitration tribunals seated in New York or having a connection to New York, how do they approach costs issues? Because it's often a question, especially coming from a jurisdiction where the domestic presumption is that each party bears its own costs, right? That's called the American rule. So to what extent are international arbitration tribunals influence that? You always wonder, you think, this is how I do it, this is how we've seen other people do it, but to what extent does that cultural norm, that domestic norm, influence the international arbitration practice? So we undertook a look at that, and the results were fairly similar to what came out from the YCAP Secretariat report. In international arbitration, definitely the loser pays norm prevails, but what that means and how, whether you recover all of your costs or not is something a little bit different. I think we're going to talk about that as we go further, but 90% of costs were recovered in the awards that we were able to find information about where that norm applied. And the YCAP report found it was 80%. So those are broadly in line. So I think that's an interesting result.
Absolutely. So moving on to the same subject, different cost awards across different jurisdictions and cases, I wonder if you see any role that an arbitration institution can play in that topic.
Sure. So, I do think that arbitral institutions play an important role in managing costs generally, because arguably the starting point for any decision on costs are the applicable arbitration rules. I also think that, broadly speaking, arbitral institutions own or have some sort of duty of care towards their users to make sure that to ensure an effective and cost-efficient resolution of their dispute. And there are many ways in which an arbitral institution can, let's say, discharge this duty. And I will focus on two very briefly. First, providing guidance and means to ensure that proceedings are indeed conducted in an effective and cost-efficient manner. And the ICC does that in part through its Commission on Arbitration and ADR, whose work results in concrete guidance and useful tools, including in reports that are available to the public. One of these reports, as I said, is on costs in international arbitration, and again, it's available online, and there are many other reports. The second way in which arbitral institutions play or may play a role in regards with cost awards is basically with including provisions on cost in their arbitration rule. As I said, the arbitration rules are arguably the starting point for any decision on cost. On a preliminary basis, the ICC rules ensure predictability in terms of cost because it provides that arbitrators' fees and the ICC fees are fixed on an ad valorem basis. So this enables the parties to have an idea as to at least, it answers in part to the question of how much will my arbitration cost. At least we can give a response to the arbitration cost. So again, the arbitrator's fees and our fees, not the counsel fees, so another issue. And the ICC rules also contain a series of provisions related to cost management, and it places an obligation on parties and arbitrators to make every effort to conduct the arbitration in the most expeditious and cost-effective manner. And the rule also grants a broad discretion and authority to arbitrators to make sure that the parties comply with this obligation. And the ICC in turn has discretion when fixing the cost of the arbitration pursuant to the rules to consider the diligence of the arbitrators and whether they managed or conducted the arbitration in an efficient manner. And lastly, and very importantly, in the context of an ICC arbitration, the court also has a role when scrutinizing draft awards. Unfortunately, experience has shown that decisions on costs are not always thoroughly analyzed and are not always well drafted. Probably because it's, if you're reaching the end of the award, probably the arbitrators cannot anymore and they kind of want to wrap up. So I think cost and interest are one of the main issues that we see at the ICC court when we are working on the review of the draft award. So this is just another example of a role that arbitral institutions have.
Thank you, Paul. And I agree with you that sometimes cost and interest may become like an afterthought. So I would ask Hugh, maybe when should counsel start thinking about those costs?
Maybe that like this conference, you start thinking about costs right at the start, even though it is coming in closer to the end. There's a lot of reasons to turn your minds to the issue of costs at the outset. In part because the fatigue that one feels, maybe, or that an arbitrator feels at the end of the process is not isolated to the arbitrator alone. And counsel may feel that fatigue as well, and also the pressure of closing submissions and other aspects of wrap-up. So there is a great deal of organization that can be handled up front in dealing with costs. I always like to start a new marking system with a new matter number or some other way to begin delineating individual costs for an arbitration once it has started. And I also find that the impetus for tracking costs often comes from pressures around the need to deliver budgets and other demands of clients and parties. that are looking for some transparency over what will happen in this process. So if you're feeling particularly emboldened to be as organized as possible, it's always nice to be able to approach the issue of costs in your own accounting so that you have a tracking system that allows you to categorize the work that you're doing to particular phases of an arbitration, that itself tracks the procedural order that has been established so that with relative ease you can extract costs not only for the arbitration as a whole, but in segmented portions to particular phases of the arbitration. This, of course, requires some planning up front. I think it's also worth thinking about as you go along the costs phase, because it can allow you to turn your minds to the documents that might be required, the moments of added effort that you may want to claim back at the end of the process. So setting aside documents midstream, even jotting out some of the arguments of the key points can be important as you go along. Because not only is it going to be harder work at the end of the process to excavate that information, you may not have quite as much time to do that. There's also a psychological effect perhaps over time that I find usually leads to a deterioration of the real strength of the argument. So capturing that as you go is very helpful.
Absolutely. Stephanie, would you like to add something to that?
Well, maybe I'll pick up on this idea about arbitrator fatigue and suggest that it's not necessarily so much that you're tired at the end of the case and how am I going to wrap this up, or I don't want to pay attention to it. Although maybe some people draft awards that way, and maybe that's how it happens. But I think probably more often than not, what we're dealing with is that costs are an area where there's tremendous discretion. And there are things that are sometimes challenging to put into writing, which is just a reality. I think, we're going to talk a little bit about, how you pitch your costs award, but understanding that arbitrators are exercising discretion, having that understanding that even if it's a winner takes all norm, that there's a haircut that typically applies. So start thinking about what are the grounds on which an arbitrator, a tribunal is going to apply that haircut. So I think that the institutional role that Paul was talking about, the scrutiny process, is very important because discretion should never seem arbitrary. And that's the thing that I think people get upset about when you read a cost award where it does seem like a finger in the air, and it shouldn't be a finger in the air. And I think most of the times it's not a finger in the air. But it's what actually does somebody read and what does someone actually put into the award. So I know we're going to go there, so I won't preempt you, but that I think is where the difficulty lies, is convincing the tribunals to put those reasons in there. How do I lead them where I want them to go to give a decision that lines up with sort of my case as the case that I have, and then the tribunal's giving to parties what they rightly expect, which are reasons that support the exercise of that discretion.
Absolutely. I see your point when you say pitch your cost awards, and there is this strategic element to that as well. And building on that topic, Hugh, this is a question for you. Because we promised this audience do's and don'ts of cost awards, I would like to ask, how should we present the cost award, particularly if the opposing party was unreasonable? How do we support that?
Well, I'm uniquely qualified to discuss the details of unreasonable opposing counsel, so thank you for the question.
From which side?
Let me start by recalling some of the comments that we've heard so far during this conference. On Sunday, a comment that Thomas Cromwell made at our LCIA, I should say following the event, as a sort of a wrap-up, was that there is a sense that parties are looking for something other than litigation in a boardroom, and that concept came up again today. And so One thing that we are seeing, I think, quite definitively across Canada is that arbitration is offering something different when it comes to the treatment of costs as compared to court litigation. So when presenting a costs position, it seems to me that there's every opportunity to embrace the uniqueness of arbitration and the space that Canadian law and arbitration acts give to arbitration to be different from litigation. And I did a little bit of collection of some of the decisions that relate to this concept of cost allocation and arbitration as compared to litigation. And there really is a very clear articulation of what is possible in arbitration when it comes to costs. And for instance, in New Brunswick, as well as British Columbia, there's cases now that I think are becoming increasingly relied upon that speak to the fact that A, court fee scales are not applicable to the allocation of costs in arbitration, and that's one point. That's what opens the door. But B, that the norm in arbitration is full indemnification of costs. Now, some of these cases that have since moved to other jurisdictions, including Ontario, speak to near full indemnification. Others speak to full indemnification of reasonable costs. And it seems that those two things are a little bit different. I suppose in looking at what the YCAP report identified, which is an 80% recovery on costs, that can suggest that arbitrators are grappling more with the concept of full indemnity of reasonable costs as opposed to full indemnity of actual costs. But I think it would be a mistake to ignore this uniqueness of arbitration when presenting a costs award. It could be marshaled in a couple different ways, but clearly there's something unique about arbitration that ought to be recognized.
Absolutely. Stephanie, I'm looking at you because I know you have some things to add on.
Well, I mean, I think there are two different factors that come into play again on the exercise of discretion. One is the idea, even though we talk about the sort of winner takes all, cost follow the cause principle, you rarely have a party that prevails in all respects. And so thinking about the relative successes in the context of the case is one of the ways in which you see that haircut arise. So if we go back to the strategic question about, how do you pitch your case on costs to the arbitrator, it's making I think a case about relative success. And you can do that before, the timing of when the cost submissions come in obviously change a little bit the character of how that pitch gets made. But I think if you're trying to convince the arbitrators to exercise their discretion in a certain way in terms of awarding the costs, focusing on success, what does it mean to have been a successful party if it's the winner takes all, that's the number one thing to focus on. So that could be, in terms of the claims. It could be in terms of success on, maybe there was going to be meritorious claims, but the damages case was ridiculous, and there was a lot of time and effort spent on that. So maybe you can make an argument about success on that level, or maybe it has to do with applications that were made throughout the course of the case, or, right? So you can pitch successfulness. What does it mean to have been the prevailing party, the winning party? That's one way in which you can kind of both focus the discretion and the decision making. And the second is the reasonableness, I think that Hugh was mentioning. So the catch there is recognizing, when I said there are things that maybe an arbitrator doesn't want to put into writing, if you are going to make a costs application where you're going to focus on how horrific the other party is, they acted in bad faith, they drove the costs up, and mostly you're going to pitch it in terms of very personal, ad hominem terms, or not back it up with concrete milestones from the course of the case, you're not going to be persuasive. I do not see any reason to call out Powell or Hugh for being horrible people during the context of a case. Not that I ever would, but I mean, if you imagine that there really was that bad behavior, that it was that bad that it's necessary to sort of name and shame someone and then the award is going to a client, I mean, it's not necessary. It detracts from the merits of the commercial dispute. So any comments that I'm making in the context of an award, any reasons that I'm giving, I'm going to want to have them be more in line with the merits of the dispute as much as possible, as opposed to focusing on counsel. I want to focus on the parties for the most part. So how do I see counsel behavior reflected in a sort of a party kind of way? Too much kitchen sink approach on all the arguments that were raised. What was, I'm less likely to call something frivolous, but maybe I might call something frivolous, but I'm really unlikely to say that counsel was acting in bad faith, right? So how you pitch it in that way, I think has a lot to do with what kind of reasons you end up getting. Because if you really want to get a reasoned decision and you want to force arbitrators to exercise their discretion in a fair, balanced manner, then you have to lead them there. So you have to give them cost submissions where you say, if you've teed it up to say, that Powell, team, that party made, these 5 applications, they failed on all of these, or they asked for all of these documents and none of them ended up being used. It was 10 core, documents. That's something concrete. That's something you can point me to. That's something you can see in reasons. And it could still be that he was acting in bad faith. It could still be that they were acting horrifically, but it's the tone, right? So that, I think that makes a huge difference.
I agree. I think Hugh has something to add.
Yeah, I think these points are illuminating and really very helpful. And I do want to pick up on some of the points about discretion in particular, the exercise of discretion. 2 thoughts really. The first is that though the arbitration rules are, as I think we all know, quite open when it refers to the awarding of costs, there is nevertheless some guidance embedded in all rules, virtually all rules on the awarding of costs. And there are differences, for instance, between what the UNCTAD rules say about, in principle, the unsuccessful party shall bear the cost of the arbitration versus the ICC that takes a bit more neutral of an approach and speaks to general factors and taking into consideration a myriad of issues rather than highlighting this concept of successful or unsuccessful. So that though discretion exists, it's not that it's not unbound, and it does have some direction. But the second point is that I find that the presentations that we received from the YCAP group today, as well as the Canadian arbitration survey that is available, are incredibly useful in trying to think about how to craft and develop and understand issues of discretion when the arbitrators are involved, because it is difficult to know exactly what people are doing. And the ICC is really quite prolific in terms of its publications over how its rules are often applied, how they may be applied, what they see in terms of practices of individuals. And I could say, for instance, what we just saw from YCAP, we saw data that really shows that 80% of costs for successful parties are being awarded. And the number of instances where party conduct specifically or allegations of dishonesty are directing the outcome of cost submissions is actually quite low. So that really, I think, supports what Stephanie's saying. It really should guide parties in terms of how they present arguments. Now there's an authority that actually you can cite in your cost submissions, which is really quite helpful and not something we had before. So I say congratulations and thank you for that.
Thank you. Yes. Now I'm going to move with third-party funding and costs. And Geoff, this question goes to you. Do arbitrators, you think, handle cost awards differently when they know that the case is funded?
Yeah, it's a good question, and I think the key
to that question is when they know that the case is funded. So there's a few interrelated issues here. First is disclosure. And if the funding is not disclosed, and it's not always disclosed, then there's nothing for an arbitrator to think differently of or react to. The trend is, of course, towards disclosing of funding. Most institutional rules now require it. And the practice, I think, of most funders and parties who are funded, I think, should be to disclose it proactively, even if it's not required, simply because you're going to create issues both within the arbitration and potentially for the enforcement of it afterwards if it then comes out later and the parties weren't given, or the respondent wasn't given an opportunity to address it at a meaningful time. So then the second issue is assuming an arbitration is, or funding of an arbitration is disclosed, is what exactly does the funding arrangement indemnify? Often in cases of jurisdictions where the expectation is that there's a loser pays cost outcome, a funding arrangement will indemnify for adverse costs, but not always. It's an individual negotiation with each client that's funded. Sometimes they don't want adverse costs coverage because it does add an expense to the funding that's reflected in the price of the funding. Sometimes there's insurance that covers part of an adverse cost award, but not all. And so that's the existence and extent to which an indemnity covers adverse costs is going to be probably the first thing that the responding party and the arbitrators will put their mind to. And where you see this come into play in terms of how a tribunal might actually react differently when there's funding in place is when there's a security for costs application. And that's, frankly, one of the drivers working backwards of whether or not a funder is going to be willing to and thinks it's appropriate to provide adverse cost coverage at all. Is that if you get, if a funded party is proceeding with a claim and a successful adverse costs or sort of successful security for cost application is brought, and there's no coverage for that, it stops the arbitration in its tracks. So there has to be some way to deal with that if you want the arbitration to proceed. And so the next thing that a tribunal and responding parties are going to pay attention to is, is security for costs covered? How? Is it covered by payment of cash into some account? Or more commonly, what a well-capitalized funder will do is provide an undertaking to the tribunal that says, here's our market position, here are our public financials, we are good for any costs award. We'll return to the jurisdiction of the tribunal, and we'll agree to provide a direct right of recourse against the funder or to the respondent to enforce that costs award. And so if a funder can provide security for costs on that basis and the respondent accepts it, often that is accepted by the tribunal, but not always. So you see, if you look at some case law from the last, let's say, 10 years on this issue, it's a bit all over the map. You have some tribunals saying that the existence of third-party funding itself does not justify an award of security for costs. And I think that there's some accepted wisdom out there that security for costs in international arbitration is supposed to be an extraordinary remedy. And so some tribunals start from that analysis, but there are others where there's funding that has been disclosed and there's some other factor in the background, like a history of the claimant of not paying costs awards, or when there's disclosure of the funding, it turns out there isn't an indemnity for adverse costs. And in some of those cases, then the tribunal has said, we will order security for costs. There's not a ton of uniformity between this case law. The ICA Queen Mary report on third-party funding, when it was released in 2018, I believe, their recommendation was that any security for costs analysis should be on the basis of the applicable security for costs test without regard to the existence of funding. And then you only consider funding after the fact to the extent it will cover or how much it will cover adverse costs. Tribunal decisions since then haven't so much taken up that recommendation. So what we've seen is more and more tribunals saying, okay, so we see there's funding, we've looked at the terms of the funding agreement, and we see there's no indemnity for adverse costs or security for costs, so we're going to lump that in under extraordinary circumstances and make a security for costs order. So whether or not that affects, like the presence of a funder itself affects the tribunal's thinking, I would be, I guess, speculating a bit, but my anecdotal observation is maybe a tribunal has more comfort making an order that is otherwise extraordinary when there's the perception that there's a deep pocket on the other end to provide security for costs. Yeah, I think that's more where we see it actually come out in decisions that are available.
And what about the costs of funding themselves? Are they recoverable?
Yes. Maybe my favorite topic. It is an emerging area, and it's one that I'd like to say, not surprisingly, as a funder, is a growing trend. But this concept is really that in addition to getting the actual costs back of the arbitration itself, the fees and disbursements, that the cost of obtaining funding is a cost that should be recoverable in the arbitration. And when I say the cost of obtaining funding, I should be very clear because sometimes people are surprised at what that means. It actually means the funder's fee for providing funding. And so when you think of how a third-party funding arrangement is structured, it's the return or the fee is going to be either a multiple of what was spent or a percentage of the recovery, so it's substantial. And that's an amount that is increasingly being sought as costs. And it's not just a trend that I'm putting out there and there's proof for it. It's actually happened a few times and has started to be codified or at least recognized in some institutional rules. There's not a ton of case law about this out there that you can review. The one that gets cited most commonly is a 2016 UK case called SR Oilfields, and it was really a refusal to set aside a partial award of an ICC arbitration. And that ICC English-seated arbitration, the arbitrator considered it reasonable in the interests of justice to award funding costs of over £2 million, which was the funder's fee. And that's because of specifically, and I quote, reprehensible conduct going far beyond technical breaches of the contract, which itself pushed the claimant into the state of financial distress that caused it to seek funding. And so that element where the respondent's conduct has caused the claimant's financial distress and caused it to go and get funding has sort of been unofficially adopted as like a test for when you can get the cost of funding, is there has to be this blameworthy element by the respondent. But following that decision, we've seen a little bit, I think that's come into question a little bit. There was a 2021 case, and again in England, the Katanga Contracting Services case, that again upheld an award where third-party funding costs were granted. And in that case, it didn't necessarily have the same morally blameworthy conduct on the respondent's part. And the tribunal specifically said that that is not a determining factor. And so since that time, we've had this, we've seen this show up in arbitration awards, specifically in Singapore and some other jurisdictions where, like the ICC, the rules say that legal and other costs of the arbitration are recoverable, and tribunals have used that as a hook to grant the award of third-party funding costs. There was one case in 2020 where the tribunal, although it did not award costs of funding in that case, said they are definitely recoverable under that rule. And the tribunal shall have that authority because that provision under the SIAC rules is extremely broad, such that it provides the tribunal with authority to order third-party funding costs as long as those costs are incurred in connection with the arbitration. There was another case that same year from the same institution that we funded that did grant the full costs of funding, that we press released the fact that this exists, but the rest of the case is confidential. So that's all I can really say about it. But these cases do exist. People, they're not that public yet, but we expect, given that this appears more in the rules, and that the tribunals are more comfortable with this, as they get more comfortable with this, that we'll see more of them. The Singapore case that I mentioned that declined funding, part of the reason, or declined the cost of funding, part of the reason it did so was because the claimant was not impecunious in the same way that the SR claimant was. And so that impecuniosity part of the test still remains for some tribunals. And so I think what you can take from this is you need the tribunal rules to allow you to do this. You probably still need some impecuniosity of the claimants that was caused by the respondent. And frankly, on the sniff test, the
the tribunal is probably not going to allow a giant windfall to a funder right from this. It's like, in all of the cases that have granted this, the amount that was granted as funding was not disproportionate to what was at issue or awarded in the arbitration itself. So that's, I think, the third factor that parties and tribunals should think of when they're looking at awarding or making pitches for awarding costs of funding.
I see that we have 3 minutes to go, and we have so many questions on the agenda, I know, but I would like to turn to the audience and give them a chance to raise any questions they might have. Oh, I see one question over there.
Yeah, I have a question. How would that be different than a situation in which a firm took on an arbitration on a contingent fee basis and recovered, say, a third of the award? Would the tribunal add a third to the award? Because the funding cost would have been the contingent fee. What's the difference between that and third party?
Yeah, it's a good question. In that situation, it's the firm that's taking on the risk. It's not, well, you're right, it's a cost to the client in the sense that it is coming out of their award. So in theory, there's nothing stopping it from being also applying to contingent fees to the extent that they're allowed in that particular rules regime. I would think there's maybe a substantive difference between extending actual money and putting time at risk on behalf of the firm.
Firms don't look at it that way.
I know firms don't.
It's time is money, and out-of-pocket expenses are money. You're paying your associates, your assistants, and so on, and the experts that you have retained and so on. You're paying all of that. Anyway, it just raises a question in my mind.
I think the contingency fee question is very difficult, and I think one of the things that I've seen come up in a couple of cases where I've had that issue is people argue about whether they had notice at the outset of the case. And some of this ties into what you were sort of saying about, whether the respondent was responsible of it, because in some jurisdictions there at least seems to be a sense that it can't just be, there's got to be a reason why they had to have the contingency fee arrangement. They don't want to give like an uplift to the law firm at the end, but there's some jurisdictions that seems to be okay. So that's a very thorny kind of question, but I think if it hasn't been raised at the outset with the other side, so they at least know that there's a risk, that seems to be something that in some of the cases that you see where that makes it much more problematic, and that the courts then looking at whether you could award it, whether that could potentially raise some kind of public policy issues.
Yeah, there's a fairness issue there that in that Singapore case that did not grant the cost of funding, the fact that the claimant did not meaningfully or disclose it at a meaningful time was one of the reasons why that was declined in that case.
Because it factors into your settlement analysis and so on. So like if you go forward with the case, that's I think the rationale behind that.
Okay. I'm sorry to interrupt. We're right on time. Thank you so much for everyone. If you have any questions, come find us in the coffee break. Thanks.